Hello everyone, welcome back to the channel. I hope you all are doing well. In this video, we will discuss about a specific relief called declaratory decrees. This specific relief is coming under chapter 6. Under chapter 6, we will find two sections, which is section 42 and section 43. Under section 42, it is written that two kinds of person can file a declaratory suit for two matters. First, any person entitled to any legal character. Legal character includes sex, minority, official position, ranks, caste, nationality. So, in regarding these matters, if any dispute arises, then that kinds of person can file a suit. Then, any person entitled to any right as to any property. So, if a dispute arises regarding any right to property, then that kinds of person can also file a suit. When he will file the declaratory suit is also written in section 42. Here it is written that that person may institute a suit against any person denying or interested to deny his title to such character or right. So when other will deny his title to such character or right, then he will file a declaratory suit. So here denial of his character or right is precondition for filing a declaratory suit. Here it is also written that the court may in its discretion make therein a declaration that he is entitled and the plaintiff needs not in such suit ask for any further relief. So here in this point basically it is said that court has discretionary power regarding giving declaratory decrees, and plaintiff does not need to ask any further relief in order to get that declaratory decree. There is a proviso of this section which is said that the court shall not make any such declaration where the plaintiff being able to seek further relief than a mere declaration of title omits to do so. So, if a plaintiff was able to seek further relief then a mere declaration, but he omits, then court will not make such declaratory decrees. It is said in proviso. Now we will know what is further relief and when this proviso will be applicable. Here further relief denotes consequential relief. The relief which is ancillary to the main relief is known as consequential relief. If the plaintiff is able to ask relief but he omits to ask, then court will not give declaration in any manner under this section. The purpose of this section or condition is to avoid multiplicity of the suit. Here the court will not dismiss the suit at the first instant. Court will give an opportunity to the plaintiff to amend the plaint. So when the consequential relief or further relief is not asked, where the plaintiff needs to ask or where the plaintiff was bound to ask, then court will not dismiss the suit at the first instant. Court will just give an opportunity to the plaintiff to amend the plaint, and after amending the plaint and including there the further relief or consequential relief, plaintiff can file a suit against for declaratory decrees. For example, if a person has no possession in his immovable property but he filed a suit only for declaration of title under this section, then this suit will not be maintainable unless the recovery of possession is asked also as consequential relief. If a land of one person is encroached by another, then he can ask for declaration of title of two land, and here he also needs to ask for perpetual and mandatory injunction for the prevention of encroachment on the land, and injunction here is consequential relief. So here if we see the second example, if a person is dispossessed or he is not possession in the land and he files a declaratory decrees, that court will give a declaratory decrees and his title will become absolute. But here, if at the time of filing the suit in the plaint, if it does not include recovery of possession with the declaratory decrees, then the court will not give the relief of declaratory decrees under this section. So in the plaint, a person needs to also ask consequential relief with declaratory decrees, because otherwise court will reject that plaint, and the party against whom the plaint is rejected needs to amend that plaint again and needs to file the plaint again. The purpose of this proviso is that if a person get declaratory decrees, his title will be established, but the problem is the other person who is in the possession of his land in which he gets the title is not yet or has not yet given him the possession. So how he will take that possession? Only title deed or only title will not give him the possession. Here he also needs to file a suit for recovery of possession. If in the declaratory decrees recovery of possession isn't asked, then he needs to file another suit for recovery of possession. So there will be multiplicity of the suit. Here to evade this multiplicity, this proviso comes into existence. So here, if the consequential relief or the further relief is not asked in the plaint with declaratory decrees, then court will reject that plaint and the plaintiff needs to amend the plaint, where he also needs to add the further relief or consequential relief, and then he will again file that suit. Now we will take an example of a situation where declaratory decrees may be asked. For example, A is lawfully in possession of certain land. The inhabitants of a neighboring village claim a right of way across the land. A may sue for a declaration that they are not entitled to right so claimed. So here a dispute arises regarding whether the neighboring village has a right of way across the land owned by A and possessed by A. Here A can go to the court. Here the woman is A and these are the neighboring village people, and this is the road, and they try to say that in this way they have right to way. Okay, but A denies that. So a dispute between or among A and these people arise, and how now here A can file a declaratory decrees under which, if courts say that the village people don't have the right of way in this land, then this will be a declaratory decrees. Court declare here just. Now if we go through section 43, we can understand what is the effect of declaration. There it is written that a declaration made under this chapter is binding on the following parties to the suit. So the declaration is binding on the parties of the suit, then person claiming through them respectively, and where any of the parties are trustee on the person for whom, if in existence at the date of the declaration, such parties would be trustees. So these kinds of people against whom the declaration is binding. So if we go through this section, we can understand that declaration will not be binding on the third party. This is all about section 42 and section 43, which is basically talking about declaratory decrees. Thanks for watching this video.